here and then camera will be.
That will be
Actually,
better.
the camera works this way only. When you click this button, the camera will focus on you.
Okay,
And
because
it
this is online.
online.
Okay.
वो जब कैमरा चलेगा तो उसके ऊपर आ जाएगा, जो भी बंदा माइक प्रेस करेगा
Okay,
तो
this is
वहाँ पे
online also. So
Good afternoon, one and all. We have gathered for the plenary session where we have officers from the Insolvency and Bankruptcy Board of India who will be sharing their insights and their practical experience so far as the implementation of this important enactment, that is Insolvency and Bankruptcy Code, is concerned. First, we have with us Ms. Namisha Singh and Ms. Sanchal Raj. Ms. Namisha Singh is a manager at IBBI, Manager Advocacy, and as stated in the morning, she is instrumental in execution of the MOU between the Rajiv Gandhi National University of Law and the Insolvency and Bankruptcy Board of India. So she will be presenting on conundrum and cures, analysis of the interplay between Insolvency and Bankruptcy Code and other laws. Over to you, ma'am. Thank you.
thank you so much for the introduction, sir. So, good noon, everyone. I, along with my co-author, Ms. Achal Raj, will be presenting this paper on conundrum and cures, an analysis of the interplay between the Insolvency and Bankruptcy Code and other existing statutes. So, before delving deep into the nitty-gritties of our research paper, I would, if you can just change the slide. So I would like to mention that the views that we have expressed in this research paper and the presentation as well are our personal views of the authors in our personal capacities, and we have written this paper solely for creating awareness on this particular subject. So, as we all know, that since enactment of Insolvency and Bankruptcy Code 2016, it has been very dynamic. It has been a landmark legislation which was introduced for streamlining the insolvency and bankruptcy framework of in India, and to bring a time-bound resolution mechanism for the distressed businesses in India. Thank you. So yeah, what I was saying was that the Insolvency and Bankruptcy Code has brought out an time-bound resolution mechanism for the distressed businesses in India. So before going forward, I want to give a brief snapshot of the corporate insolvency resolution process under IBC that we have. So I am sure that everybody must be well equipped with the CRP process here, but still I would like to reiterate the whole process for setting a tone. So any corporate debtor having a minimum debt and default of rupees 1 crore is eligible for application and admission of its CRP under the code. And This application for CRP is admitted by the adjudicating authority, which is the NCLT under the code, and it also, with admission of the whole process of the CD, it also appoints an insolvency professional for taking care of the operations and management of the corporate debtor during the corporate insolvency resolution process. And it initiates a moratorium, often called calm period, during which there is no possibility of no suits or legal proceedings can be initiated against that corporate debtor or its properties. So it is section 14 of the IBC. Thereafter, the insolvency professional publishes a public announcement intimating about the CRP of that particular corporate debtor for the larger good of the public. Thereafter, the insolvency professional forms the committee of creditors and appoints a registered valuer to determine the fair value and liquidation value of the corporate debtor. Thereafter, he or she prepares a information memorandum of the company, which includes the audited financial system, financial details, assets and liability details, list of creditors, list of litigations that are ongoing or pending for the company, and the list of guarantees it has provided, all these things, and then it publishes an expression of interest for the purpose of request for resolution plans. Thereafter, the insolvency professional receives resolution plans from prospective resolution applicants ideally within a time frame of 135 days. And after this, all the resolution plans are presented before the committee of creditors, so formed by the insolvency professional, and they use their commercial wisdom to decide on and select on the resolution plan. And thereafter, once selected by the COC, it is sent to the adjudicating authority to see the legal aspects and finalize whether the company is to be resolved or liquidated. So the whole process that we see is a process of 180 days, which can be extended by 90 days, thus giving us a timeline of 270 days, which can also be further extended to 60 days. That is, 60 days time period is for the litigation period that happens during the CRP process. So keeping this process in mind, we'll be starting with the research paper that we have tried to carve out. So this is the flow of presentation for a research paper. The introduction, rationale of study, objectives and intent behind writing this research paper, the stages of interplay of IBC with other existing statutes, the existing jurisprudence at different fora, conclusion and the way forward. So while writing this research paper, we had in mind that there are several stages in a corporate insolvency resolution process wherein the intertwining of IBC with other laws sets in. So keeping that in mind, we have tried to understand various facets of insolvency and bankruptcy code and its intertwining with other laws. And the other laws that we have covered here in the research paper are Securitization and Reconstruction of Financial Assets and Enforcement of Security and Trust Act, Real Estate Regulation and Development Act, taxation laws. We have also considered Tea Law, Tea Act, Electricity Act, Prevention of Money Laundering Act, Arbitration Act, and many more. So the rationale of this research paper is that we had observed there are many issues which are leading to litigations during the corporate insolvency resolution process, thereby delaying the whole process. There were issues like there were departments and authorities attaching the properties of the corporate debtor or bank accounts of the corporate debtor during the moratorium period, or there were taxation authorities who were implying 1% TDS for transfer of immovable properties, like that. There were employees' dues and arrears issues. So we have tried to identify the issues, and based on those issues, we have tried to identify the orders of different fora, and we have tried to collate them so to understand the stance as of today, existing stance on these intertwining of laws. The objective is to understand, as I would like to reiterate that to understand the interplay of the code, we have written this paper and analyzed the existing jurisprudence. We have analyzed orders of different fora, and we have tried to contribute to the ongoing discourse on enhancing India's insolvency and bankruptcy framework. We have also tried to facilitate ease of doing business by writing this paper and promoting economic growth in this section. So, with this, I would hand it over to my co-author, Ms. Aanchal Raj, to take it forward.
Thank you, ma'am. After the elaborate description of the whole CIRP process, we'll now see the stages during which the interplay between other laws and the provisions of the code occurs. Firstly, the very first instance where we can see the interplay is at the stage of admission of an insolvency application. When an insolvency application is filed by any creditor, the court is required to see whether that creditor is even eligible to file the application, and these eligibility requirements arise from the agreements that the creditors enter into with the concerned corporate debtor. Therefore, it becomes imperative to see whether the contractual rights can be enforced and whether it can be harmonized with the provisions of the code. Next stage would be the applicability of moratorium. As soon as the application is admitted by the NCLT, it declares a moratorium on the assets of the CD, whereby the assets cannot be disposed of. This is done for protecting the value of the assets and for maximizing the value of the assets. At this stage, various other laws like state laws interact with the provisions of the code. In the coming slides, we'll see how moratorium has been given a sanctity even when it is interacting with other laws. Next stage is processing of claims. Whenever claims are filed, the RP is required to see whether those claims are valid or not. And a very important aspect is that of claims of employees. So during claim processing also, we can see that the provisions of IBC interacts with various labor laws. Next, if at the stage of approval of resolution plan, in the case of SR Steel, the Supreme Court held that the clean slate principle applies, and this principle states that when an SRA acquires the assets of the CD, which has been rehabilitated, it should not be faced with any sudden claims which have not come beforehand. During approval of resolution plan, sector-specific regulations may also come into play. For example, the company may belong to the telecom sector, or there may be an electricity regulator that their regulations apply, and therefore resolution plans should also consider those provisions, and those provisions should be adhered to. All laws should be adhered to. At the stage of liquidation, the interplay between IBC and property laws becomes evident because sale of assets occurs during this stage. Now we'll discuss the existing jurisprudence that there is. In the case of Rajendra K. Bhutta versus Maharashtra Housing and Area Development Authority, this case was decided by the Supreme Court. The bench consisted of Justices R.F. Nariman, Ravindra Bhatt, and Ramasubramaniam. In this case, there was a tripartite agreement that was entered into among three parties. Under the tripartite agreement, the CD had a license to enter upon a property and develop the property. This license provided the CD the occupation of the property. So the Supreme Court held that the occupation means physical possession of the property, and therefore Section 14 would apply. The contention was that the Housing Development Authority terminated the license that was granted under the agreement and wanted to repossess the property. So the Supreme Court held that this notice that has been issued for termination will not survive in light of Section 14 of the Insolvency and Bankruptcy Code. In the case of Pioneer Urban Land and Infrastructure Limited and another versus Union of India, this was again decided by the Supreme Court, and the bench consisted of Justices R.F. Nariman, Sanjeev Khanna, and Justice Suryakant. In this case, the Supreme Court was faced with the interplay between RERA Act and the IBC. The court ultimately held that the IBC and RERA operate in different realms, but if there is an inconsistency between the provisions of the two, the code would prevail and RERA would have to take a back step. Next, in the case of Innovative Industries versus ICICI Bank, this was again a Supreme Court judgment pronounced by the bench led by Justice R.F. Nariman and Justice Sanjay Kishan Kaul. In this case, the Maharashtra Relief Undertaking Act consisted of a provision whereby the government issued two notifications because of which the liabilities were temporarily suspended. The liabilities of the CD were temporarily suspended. So the contention of the CD was that the liability or the debt has not become due and payable. The Supreme Court, while interpreting the provisions of IBC and MRUA, held that if MRUA is given, if MRUA is applicable, then the provisions of IBC would take a back step and would not be able to, and the CD will not be able to be rehabilitated. So the Supreme Court held that MRUA being a state act and IBC being a parliamentary act, the IBC would take precedence over the act, and Section 238 of IBC would override Section 4 of the MRUA. Section 4 of the MRUA also imposed a moratorium, but Section 238 of IBC, read with Section 14, would precede that and would be applicable in this case. In the next case, the provisions of T Act and IBC interacted. In this case, it was provided under the T Act that in case any winding up proceedings were to be conducted or an official liquidator was to be appointed, the consent of central government was mandatory to initiate such proceedings. But under the IBC, no such consent is mandatory. Therefore, in this case, the court held that the consent of central government will not be required as the provisions of IBC will override the provisions of the T Act. In the case of Principal Commissioner of Income Tax versus Morne Ispat, the Supreme Court simply held that because of the existence of Section 238 of the Insolvency and Bankruptcy Code, which is a non-obstant clause, it is evident that it will override all other provisions which are in inconsistency with the provisions of the code, read with Section 238. In the case of Om Prakash Agarwal, liquidator of S. Kumar's Nationwide Limited versus Chief Commissioner of Income Tax, in this case, the liquidator conducted an auction and a property of the CD was sold. On this sale, there was a 1% TDS that was being levied by the successful resolution applicant and the income tax authority. It was contended by the liquidator that such imposition of TDS is against the waterfall mechanism that is required under Section 53 of the code, as it gives precedence to statutory dues over other secured and unsecured creditors. The court, while interpreting the sections, held that Section 194IA of the Income Tax Act, which provides for levy of TDS, will not be applicable in this case because under the aegis of the code and the objective of the code, the government dues cannot be given a priority over other dues as per the waterfall mechanism given in Section 53 of the code. In the case of Mr. Ashutosh Agarwal versus Joint Commissioner of State Tax, certain notices of attachment of bank accounts of a CD was issued by the State Tax Authority, and it was held by the court that such notices will not be issued as soon as the admission of application occurs, the moratorium is imposed, and therefore attachment orders cannot be passed. Next, we see the interaction of provisions of Insolvency and Bankruptcy Code with the Arbitration Act. In the case of K. Kishan versus Vijay Nirman Company Limited, there was an arbitration award that had been passed against the CD, and the operational debtor had challenged the award under Section 34 of the Arbitration Act. And the question before the court was whether, when the challenge is pending, whether a Section 9 application can be admitted or not. So the court held that a Section 9 application can still be admitted, even if there is a dispute which is pending adjudication. In the case of Reliance Commercial Finance Limited versus Wade Cellulose Limited, the Section 7 application was under consideration. In this case also, there was an arbitration happening simultaneously, but the court held that there is no provision of a dispute under Section 7 application. Therefore, initiation of CIRP is not hindered by a pending arbitration proceeding. Next, we see the interaction of Companies Act and IBC. In the case of Jaipur Metals and Electrical Employees Organization versus Jaipur Metals and Electrical Limited, there were certain winding up proceedings that were pending before the board, before the previous board, that is before, under the SICA Act. The NCLT thereafter admitted an insolvency application, but the High Court set aside this this admission order, stating that winding up proceedings will be carried out under the Companies Act. But the court finally held that the NCLT has been empowered to entertain the applications, and therefore the admission application is valid. Admission order is valid. And Section 238 will override the provisions of Companies Act. Next, in the case of Jagmohan Bajaj versus Shivam Fragrances Private Limited, the tribunal again held that there was an internal dispute between the directors of the company, and the directors filed an appeal stating that an insolvency application cannot be admitted while there is an internal dispute and there is a pending application of oppression and mismanagement. So in this case, the court held that because of Section 238, the provisions of IBC will override the provisions of Companies Act, and therefore a pendency of Section 241 and 242 application before the NCLT regarding oppression and mismanagement will not hinder the admission of insolvency application under the code. Handing over to Ms. Amisha, ma'am, for the later part of the presentation.
Thank you, Achal. So we'll be proceeding forward with the interplay of Insolvency and Bankruptcy Code with Prevention of Money Laundering Act. Under PMLA, we have seen that there is a concept of proceeds of crime based on which we have listed the orders. So in case of proceeds of crime, if a property is believed to be a proceeds of crime, then the Enforcement Directorate under the PMLA can attach the property by a provisional attachment order. And in case property is attached, it can also be confiscated, which means that the control and management of the property is vested with the central government, free of all encumbrances. So keeping that in mind, we have listed the orders. So the first order is Varsana Ispat Limited versus Deputy Director, Enforcement Directorate. In this matter, the appellate tribunal has held that PMLA relates to different fields of penal action of proceeds of crime, and it has to be invoked simultaneously with the Insolvency and Bankruptcy Code and having no overriding effect of one act over the other. Similarly, in the matter of Rotomac Global Private Limited versus Deputy Director Enforcement Directorate, the appellate tribunal had placed reliance on the matter of Varsana Ispat Limited, and it has held that moratorium under Section 14 of the Code is not applicable to attachment proceedings under PMLA against properties acquired through proceeds of crime. The appellate tribunal proceeded in this case on the basis that there is no consistency between the code and the PMLA, and both have to be cohesive and equally they have to be in place. So after that, there was a judgment of High Court of Delhi in the matter of Rajiv Chakravarti versus Enforcement Directorate, wherein the same issue was dealt with, and the High Court had held that Enforcement Directorate is empowered to attach the assets that are believed to be proceeds of crime only if Section 32A of the code is not triggered. So we have already discussed in the inaugural session about the clean slate principle, that the successful resolution applicant or the new management, as we say it, they should start afresh, and they should be immune to the attachment and by the ED and the CBI or SEBI. for that matter. So, however, the legal position by the Supreme Court is still sub judice in the matter of Ashok Sarvagi. So, we just have to see how conclusively it is determined by the Supreme Court. Moving forward, we have interplay of Insolvency and Bankruptcy Code with Electricity Act. So here we have placed the Pashchimanchal Vidyut Vitran Nigam Limited versus Raman Ispat Private Limited matter. So in this matter, PVVNL has appealed for release of property during the liquidation under the code for its sale and distribution of the proceeds. So here in the Electricity Act, we could see that there were two non-obstantive clauses, 173 and 174. And PVVNL had appealed that the 173 and 174 will override the section 238 of the code. However, it was held by the Apex Court that the section 238 of the code overrides the provisions of the non-obstantive clauses of the Electricity Act. This, as we were talking in the inaugural session about the rainbow papers, so which is also under review. So Pashchimanchal has also clarified on the rainbow papers judgment. So moving forward to IBC and the interplay with Surfacy. So under Securitization, Reconstruction of Financial Assets and Enforcement Security Interest Act, there is a provision for the banks and financial institutions to auction the properties of the companies under distress to recover their loans. So, uh, with that matter, we have listed out this Indian Overseas Bank versus RCM Infrastructure and other. In this, the same issue was discussed whether any financial institution can realize security under this act Surfacy during the moratorium, during the ongoing period of the CRP. So the Apex Court had held that Section 14(1)(c) of the IBC has an overriding effect over any other law. Consequently, any action to foreclose, recover, or enforce any security interest created by the corporate debtor, including its actions under Surfacy, is prohibited during the CRP. These are all the acts that we have covered for interplay of IBC. In the end, we have concluded that it is a complex process. In all, we have tried to bring out the synergies, dependencies, and any conflicts that arise. So, I understand that I and my co-author Anchal Raj have tried to conclude that we require a seamless integration of the code with these laws so that IBC can be better implemented. Further, any dissonance between the realms may lead to prolonged legal battles, which we had already observed earlier before starting with this topic for the research. And then harmonizing these legal frameworks becomes imperative to create a favorable environment for the businesses and other stakeholders. What we are suggesting that over past 7 years, we have seen that the legal aspect around IBC has evolved as it is very dynamic. The challenges we have tried to combat through various different judgments of for us, we have tried to combat the challenges, and now it is a time that there's a pressing need to educate the other authorities about the IBC across legislations. So, it recognizing its roles in India's economic growth, and there will be a call to adapt a legal framework to evolve business landscape. This research is basically based on some of the judgments of various different laws that we have covered. However, we have tried to step in so that this can serve as a guiding factor for other stakeholders to proceed forward before litigating during the corporate insolvency resolution process. So that's all from our presentation. Thank you.
Thank you so much, Ms. Namisha and Ms. Anchal Raj, for touching upon various laws which we and Mr. Anil Katia, we were discussing in the morning that insolvency and bankruptcy code, it touches upon various aspects. And there are so many laws with which it has an interface, be it law of contract, be it property law, be it taxation law, direct taxes, indirect taxes. In the morning, we were talking about mediation also. Fine. So, Electricity Act, Real Estate Regulation Act. So, probably you have set the tone for the panel discussion, which is scheduled to be held tomorrow, where we will be discussing through a galaxy of experts, where Mr. Anil Katia will also be part of that. Uh, how the IBC has its interface with various laws, and how, as we understand, though it's more than 6 years now, the law is still evolving through various adaptations, through amendments by the legislature, through issuance of regulations by the regulator, and through high judiciary decisions also. And probably we are still in the infancy stage, and in some time, in a decade or so, it will be a more mature law. Any questions, any comments, any queries, any observations which the presenters have got before we move on to the next presentation? Thank you, Mr. Katia, for highlighting that the enforcement directorate's role in IBC, of course, all other matters, taxation matters also, that is increasing, and of course, that is required to be addressed. Any other comments, observations, queries? Yes. There's another point just to add to it. As we said that the law is still at its infancy, still to settle down. The interplay is being, I mean, every other day you find some new development, new nuance of the law coming into limelight. And probably it will take time for the judiciary to settle down the interpretation. And as we discussed in the morning, the legislature has come up with a host of amendments. And I think even IBBI has resorted to more than 80 odd amendments to the regulations which they have made. They are trying to adapt the law to the growing demands. As I said, probably it would take more time to settle down. Thank you, Mr. Katia. We move on to the next presentation by Ms. Anchita Sood and Ms. Archana Sharma. Ms. Archana Sharma is Manager CIRP at Insolvency and Bankruptcy Board of India. Her paper is titled Beyond Recovery, Harnessing Value Through Asset Reconstruction Companies. I'm sorry I didn't take that question because we had reserved 1 hour, and otherwise we will be delaying our schedule by more than 1.5 hours today. So probably we will have the lunchtime with us where we can take more questions. That is 45 minutes. So I'm sorry not to have taken the question. Over to Ms. Archana.
So good afternoon, everyone present here and joining us online. This is me, Anchita Sood, and my co-author Archana Sharma. We are here to present our paper titled Beyond Recovery, Harnessing Value Through Asset Reconstruction Companies. Before we begin with the presentation, I would like to inform everyone that the views expressed in this research paper are those of the authors in their personal capacity, and this research paper is presented for the sole purpose of creating awareness on the subject and must not be used as a guide for taking or recommending any action or decisions. The researchers who want to use this can seek professional advice if they intend to use this for future. So moving forward to the research paper, in this research we have tried to eliminate the untapped potential of asset reconstruction companies, which when effectively used can be harnessed and can usher a new era of financial stability and growth. So starting with, the efficient resolution of financial stress holds paramount significance, not only for the stability of the financial sector, but also for the overall economic well-being. And the resolution of financial distress extends far beyond mere recovery. It is about the profound transformation of non performing assets into valuable resources. The two most important developments, that is SARFACI and IBC, have been instrumental in not only rescuing the distressed assets but also in harnessing their hidden potential to create a substantial value. SARFACI Act basically empowered banks and financial institutions to recover the secured loans efficiently and going beyond the traditional court interventions. And it also cemented a way for the establishment of ARCs as a potential instrument for resolving the non performing assets while simultaneously extracting and enhancing the asset value. So, if we go into the inception of ARCs, it can be traced back to the significant financial sector reform inspired by the recommendations of Committee on Banking Sector Reforms, which is Narasimha Committee 2, which was set up by Mr. P. Chidambaram, the Finance Minister of India, in the year 1997, as an effort to address the issue of non-performing assets in the banking sector. I'll be dealing with the concept of NPAs thoroughly in the upcoming slides. So basically, to tackle with the problem of NPAs, the concept of ARCs was introduced to help bank in offloading their distressed assets and focus on their core lending activities. Moving forward, asset and their reconstruction, all of us know that India's economic landscape is very complex, and it contains assets in various forms ranging from real estate to infrastructure projects to corporate loans and financial instruments. And in this dynamic environment, the concept of asset reconstruction has gained prominence as a critical process for ensuring financial stability and reviving the distressed assets. One of the fundamental pillars of asset reconstruction in India is SARFACI, which offers a robust mechanism for asset recovery, allowing the lenders to take the possession of the collateral without the need of court intervention. And this enables the swift recovery of outstanding dues. However, the significance of SARFACI Act goes beyond mere recovery, and it serves as a catalyst for the asset reconstruction, especially in the context of non-performing assets. Now, let's understand the concept of NPAs. So, it is well said that a banking system with adequate capital giving capacity helps in meeting with the demand capacity of the future. So, the process of banks extending loans to individuals, business, and various economic sectors is a fundamental driver of economic expansion. And these loans are provided with the expectation that they will be repaid within the stipulated time along with the accrued interest. This cycle of lending and repayment sustains the financial ecosystem and ensures the availability of the funds for new projects. However, when the borrower fails or borrower encounters any financial difficulties and they are unable to meet the repayment commitments, it results in what we commonly call as loan default. And in India, this default is majorly known as the non-performing assets. And NPA creation is a major issue, and as they break the credit capacity of the banks. When NPAs accumulate within the banking sector, they have far-reaching implications, and it not only affects the financial health and stability of the banks, but also ripples the economic landscape. Therefore, addressing the NPA issue is very important for the sustaining of economic progress. Now, to deal with these issues over years, successive governments have taken various steps, and they have collaborated with the industry leaders to develop various approaches to improve the non-performing asset situation in the country. Several mechanisms have been put into place to tackle this challenge. First one was DRT, that is the Debt Recovery Tribunal. And the need for such an entity arose from the recommendations which were put forth by Narasimha Committee 1, as all of us know that, which is known as the Committee on Financial System, which was commissioned to conduct an extensive examination for nation's banking infrastructure and propose comprehensive reforms to revitalize. These tribunals were set up to provide a faster and more specialized legal resources to recourse to bank and financial institutions to recover their dues from the defaulting borrowers. As a parliamentary creation, DRTs were entrusted with the responsibility to deal with loan recovery cases, but not limited to claims amounting to rupees 10 lakhs or less. However, they were also allowed, they were authorized to establish lok adalats, which in turn could deal with the cases amounting to, which could go up to 20 lakh of rupees. So initially in the year 2003 to 2004, they showed commendable results, and the recovering rate, if I can quote, was 79.1% in that year of the total outstanding amounts. However, as the time progressed, the efficiency of DRTs as an asset resolution mechanism underwent a stark decline, and subsequently through the years it started declining, which then led to the establishment of Sarfacey Act. That was established in the year 2002, and with this, the introduction of this act, India took a leap in addressing the NPA situation that was existing at that time. And this act basically granted banks and financial institutions the authority to recover the secured loans by enforcing security interest and auctioning the borrower's properties without requiring court's intervention. So, Sarfacey empowered banks to take more decisive actions to manage and recover the NPAs efficiently. Along with the Sarfacey Act, government also cemented a way for the establishment of ARCs. Now, ARCs were basically created as a specialized entities that were tasked with the acquisition of and management reconstruction of the distressed assets. They generally offer a structured approach to reviving the maximizing the value of the distressed assets, focusing on comprehensive asset reconstruction rather than merely recovering dues. Another act that was recently, as we still call it recently, that was introduced in the year 2016 was the Insolvency and Bankruptcy Code of India. And the IBC represents a comprehensive framework for addressing the financial distress across a spectrum of entities, including the corporations, partnership firms, your individuals. So IBC's goals beyond the traditional recovery method and emphasizes for the optimization of asset value. It aims at the rehabilitation and revival of financially distressed entities under the judicial supervision. Moving forward, let's have a brief look at the functioning of ARCs. So ARC, as I just told, act as a specialized financial institution that play a crucial role in the resolving of NPAs. The first step that is followed by as a function or in the throughout the ARC is the identification of the distressed assets, wherein the banks or financial institutions identify the loans or assets that have turned non-performing, and meaning that the borrower is unable to pay that as agreed. The next step is the transfer of distressed assets, wherein bank transfer their distressed assets to ARC. Third, if we may call it third, the ARCs then negotiate with the banks or financial institutions to acquire these distressed assets at a discounted price. Generally, the price is lower than the actual original value of the assets, and bank transfer these assets to ARC to clean up their balance sheets and focus on their core banking activities. Next step is the asset valuation and due diligence, wherein ARCs conduct thorough due diligence of the acquired assets, and this helps them to assess the actual value of the assets and understand the underlying business that and to formulate a proper resolution strategy for each kind of asset that they have acquired. The next step is resolution planning, wherein ARCs develop strategies to resolve the distressed assets. This can involve various approaches like debt reconstruction, asset sale, or maybe business turnaround, or if legal actions if it is required. So all these approaches are followed to formulate a resolution plan for each kind of asset that the ARC have acquired. Then they negotiate with the borrowers of the distressed assets to find a solution for repayment. This might involve restructuring the debt, offering concession, or finding alternative ways to recover these deals. Further to this, debt restructuring and asset management is also done by ARCs, wherein ARC manage and monitor the acquired assets. They might actively engage in managing the business or the to enhance the value before selling or actually resolving them. The last one is the asset sale, wherein ARC aim to recover the funds by selling the distressed assets. This can involve selling assets individually or in portfolios to investors or strategic buyers. Then recovery of funds is another step wherein the proceeds of the asset sale, debt recoveries, or the strategy resolution strategies are used to recover the outstanding dues of the distressed assets. Then once all of these things are done, then the profit sharing is done, and generally while distributing the value, the what ARCs follow a waterfall mechanism wherein the resolution and legal costs are paid first in priority, and followed by the NAV, and then followed by the security receipts that has been issued to the stakeholders. My co-author Archana will be taking forward with the presentation. Over to you, ma'am.
Thank you, Anchita, for this comprehensive overview. So now we'll move on to the role of ARCs, and if we see the cohesiveness with the Insolvency and Bankruptcy Code. So if we see that ARC is the legislation regarding ARC, that is the SARFAESI Act, that is a very focused legislation, and it was meant for the secured loans which were extended by the banks. And if you talk about the Insolvency and Bankruptcy Code, it is basically a reorganization of all the laws which are concerned with restructuring, and it has main objectives which include the maximization of value of assets of CD, then promoting entrepreneurship, enhancing the availability of credit, and balancing the interest of all the stakeholders. So, if we see the role of asset reconstruction companies in the insolvency and bankruptcy landscape, so they primarily they perform two kind of roles. One is as the initiator of the process or as a member of the COC, and another one as the resolution applicant. So as a initiator of the process, as a financial creditor, they can initiate the application against the corporate debtor whenever there is default. And in case this corporate insolvency resolution process is initiated by any other, be it a financial creditor or be it operational creditor, so in that case, it can act as a member of the committee of creditors. So essentially, committee of creditors, it is the main body which we can say it supervises the entire conduct of the process, which is carried out by the insolvency professional, and it is a main collective decision making body from which even the RP has to take approval for the major actions which are to be taken. And ultimately, it is the commercial wisdom of the COC that prevails. So in a way, we can say that ARC as a member of COC as well as the initiator of the process, they actively engage in the decision making process related to the distressed company's future, and they essentially decide whether the company is to be how the company is to be revived, how the resolution plan are to be evaluated and finalized, and how to decide for liquidation of a particular company. Now, if we talk about the another role of ARCs, which is the role of the resolution applicant, so as we discussed and heard from one of our guest of honors regarding the need for having and developing the ARCs as a resolution applicant. So, if we see the section 29A, it imposes certain kind of restrictions wherein certain persons they cannot be allowed to act as the resolution applicant. However, if we talk about the financial entities, which include the ARC, so there are certain kind of dispensations, and the section 29A restriction is not applicable. So if we look back at the history, so in the matter of Aircel Limited, so one of the asset reconstruction committee it submitted the resolution plan. It got approved by the committee of creditors, and later on, as per the SARFAESI Act, it applied for approval of the Reserve Bank of India. However, Reserve Bank of India it proceeded with issuance of a show cause notice stating that it is beyond what is provided about the mandate of the ARCs in the SARFAESI Act, and accordingly the matter went up till the level of Honorable High Court of Delhi. So the Honorable High Court of Delhi has held that there is a need for reconciliation between the provision of both the legislation, the SARFAESI Act and the IBC. So accordingly, the RBI came up with a circular in October 22, wherein it allowed the ARCs to act as the resolution applicant. However, there are certain kind of riders which were imposed. So one of the condition was that the ARCs, they should have a minimum net owned funds of 1,000 crores to be eligible to act as a resolution applicant. They need to have a board approved policy with the internal limit for the sectoral exposures, and they need to have an internal committee which will consist of majorly the independent directors, and they will decide the participation on a case to case basis. And another important restriction which was imposed that the ARCs, they are supposed to dilute their control in the corporate debtor once they acquire the debtor after 5 years from the date of approval of the resolution plan. And in case there is a non-compliance in dilution of this control, the ARCs will not be allowed to submit any fresh resolution plan or either act as a resolution applicant or act as a co-resolution applicant. Further, to enhance the disclosure requirements, the ARCs were mandated to disclose the implementation of the resolution plans which are being approved by the adjudicating authority in their financial statements. Now, after a notification of this circular, although to some extent it relaxed the provisions and allowed the ARCs to act as resolution applicant. However, if we see in the implementation part and the active engagement of ARCs in the insolvency landscape, there are still certain kind of hurdles, or there are still kind of regulatory framework which can be relaxed to allow the ARCs to further penetrate in the insolvency ecosystem. So first is the requirement of having the capital infusion. So earlier it was rupees 100 crores, but now with the circular, the capital infusion amount has been increased threefold. So it is 300 crores as of now. But if we talk about the small corporate debtors, say we have the MSMEs. So for MSME, it wouldn't be possible for a big ARCs to chase the small MSME companies for acquisition or for reconstruction. So in that way, it might discourage the big ARCs to acquire the small MSME companies, and in that way, it kind of hinders the insolvency resolution of the MSME companies. And as Anchita had mentioned in the earlier slides, the overall effectiveness of ARCs has shown a decline. So in the initial years of enactment of the code, the recoveries were as high as 70 plus percentage. However, this has now plummeted to around 20-25% now. Uh, Now, if we talk about the the role of specific role of ARC, so they need to focus on their investment on the expertise which they are possessing. So because ARCs are considered to be possessing sector specific expertise and industry specific experience, so they should focus their investment based on their experience and expertise in a particular class or particular industry. And if we look at the data which is available in the public domain about the participation of ARC, so in the insolvency framework, it has been very limited. As resolution applicant, the ARCs, they have shown very limited. The number is in single digits if we see the number of cases wherein the ARCs, they have acted as the resolution applicants. So this is one area where the ARCs need to come up, and they need to further penetrate in the insolvency ecosystem. Now, if we talk about the restrictions which have been imposed by the circular, so another condition is of having this net owned fund requirement of 1,000 crores. So definitely for the low value cases, this higher limit uh, it gets prohibited for these companies because the potential benefits are not much. If you are acquiring a small company, the potential benefits are not much. So there is no point for a big company to acquire a small corporate debtor. And the requirement of change of diluting the control after 5 years or within the period of 5 years. So this results in primary two kind of issues. One is that it hinders the ability of the ARCs to implement the plans from a long term with a long term vision, because ultimately they have to lose their control after a period of 5 years. And secondly, it encourages them to buy at a low value and then again selling it at a higher price. So the price discovery is not at the optimum level because of this particular requirement. And this price discovery issue, it has also been highlighted in the matter of Honorable NCLAT, Suparna Dhavanan versus Bharati Defence and Infrastructure Limited, wherein it was said that the purpose of insolvency resolution is not to downsize the operations of CD, but the purpose is to revive. So the resolution applicant should strive for the insolvency resolution and not just for the value addition, and with the intention to selling it off in a shorter period of time. So with these issues, if we see the role of ARCs as resolution applicants, so they serve as a driving force in the resolution process as an initiator, as a member of COC, and they facilitate swift decision making because they offer a unified, streamlined approach and sectoral specific experience. And they do have greater flexibility if we compare to the international counterparts because globally the ARCs they are government regulated entities, but if we see in the Indian scenario they are the public private entities, although they are governed by the Reserve Bank of India provision, but still they have greater flexibility as compared to the global counterparts. And if we see the need for transition from their traditional role of acting as a recovery agents to now rehabilitating and restructuring the entire corporate debtor, so I think this is something which does provide a competitive edge to the ARCs to function in the entire restructuring landscape, not only limited to the IBC. So the further points of consideration are that both the acts they should work cohesively and they should maintain a balance between the need for transparency, integrity, and fairness in the process, as well as preventing the potential abuse and the conflict of interest. On one hand, we should provide flexible approach. However, with the flexible approach, there should be some kind of stringent measures, and there should be some measures to regulate the ARCs. So, in the author's view, in our view, there should be a nuanced approach which acknowledges the significance of the regulatory controls, which allows some discretion to the ARCs, as well as it provides the leeway for the regulator, for the regulatory institutions to intervene wherever required. And in certain situations, a flexible and a lenient approach it can also be considered. So, if we are to conclude, uh, if we talk about the ARC, present ARC framework and the conditions which have been brought in by the RBI and the recent committee report in 2021, so there is a need to enhance the regulatory support and flexibility to the ARC in order to streamline their operations and in order to empower them to make more strategic acquisitions. However, simultaneously there is a need to provide flexibility and a need to focus, have a lenient approach. And for this, maybe further legislative amendments or maybe through a circular that could be brought out by the Reserve Bank of India. So ultimately, the objective should not only be limited to recovery of a particular asset or recovering a particular amount against a specific loan. So the objective is should be effective and efficient insolvency of the entire corporate debtor, not limited to any specific asset of one particular creditor. So that's about it. Thank you so much.
Thank you, Ms. Archana Sharma and Ms. Anchita Sood. Since the next presentation is also on asset recovery companies, so we'll take questions after the next presentation, if that suits. So next presentation is by Mr. Asit Behra and co-authored by Mr. Vinay Pandey, both being managers at Insolvency and Bankruptcy Board of India. The presentation title is New Era for Asset Reconstruction Companies in Insolvency, Predicting Challenges and Opportunities Ahead. Over to you, sir. Yes.
six ARCs fit into the model where they can act as a resolution applicant. Just curious, it really undermines the field of resolution applicants, ARCs as resolution applicants, which was being discussed on introductory thing also. That people emphasize that ARCs can be resolution applicants. It has to be and sensitive response. First of all, we must all understand that the Reserve Bank of India is a very, very creditable institution, an institution of repute, an institution of standing globally. What is that the Reserve Bank of India, in its wisdom, rejected the plan of UPA when they acted as a resolution applicant in the matter. You cannot just write off the view of the regulator. A regulator whose existence is older than any one of us. So there has to be some reason. First we need to unravel what is holding RBI, make them as resolution. What is that reason? So basically, because we are asking there is some resolution for housing, but there is a sufficient rate fencing around it. Normally, if they ask to act as a resolution, you form a trust for it and you redefine it. So that what happens if the CRT goes down or they're not able to implement the plan, the ARC does not go down in the process because there's essentially public money involved. But in the interest of protecting ARCs, what they've essentially done is they've forgotten the larger intent of the whole ecosystem, where the bank's health is much more important and why the ARCs were there in the first place. The limitations, everybody agreed that there had to be some limitations in place, but the limitations are very severe, and that's what we're trying to point it out. So when you have net own fund of 1,000 crores and there are only about 5 ARCs that can participate in the process, I think it's being too conservative. This is an economic law. We have to agree that this is an economic law. You have to understand that ARCs have become smarter over the years. Their role in turnaround of companies can't be downplayed. And with the passage of time, India will have specialized ARCs which will try to focus on specific sectors and they'll have their expertise. They'll bring in players from outside. So I think that aspect has been missed out. Yes. So I think maybe it needs to be looked again and revisited again. So that may be the RBI can do that. Maybe is our limited point here. There are price mismatches between ARCs and banks, which is a big problem right now, that what the bank expects and what is the ARC's valuation. And there is a lot of negotiation challenges and potential transaction delays that happens during a CRP also. Apart from that, there are various legal and operational challenges that are that the ARCs face on a normal basis that is there. I think the symbiotic relationship of, so I would talk about, so there are 3 slides. I would basically talk about what could be the way forward for ARCs and what are our expectations as ARCs in the IBC ecosystem. The symbiotic relationship under the IBC was already talked about. But there are some aspects here also that needs to be looked at. The one key area where CRPs have been suffering is that we again going back to the period of elongated resolution time. ARCs can help us put us back into that 270-day regime where they identify a good asset, take it over, turn it around in their own time, and the CRP timeline is matched. That asset is now gone into the market and they do their own turnaround and then they take it and give more value into the market. There are some process streamlining that is still needs to be there. We overall in the IBC ecosystem for valuation of assets, I think there needs to be that much more needs to be done in that area. And there's a price. There's a trust deficit right now in the market as to what the real value is between the public, between the different players in the market, between the courts and tribunals. I think that needs to be addressed too. what this will do is that the ARCs will be able to take on these assets in much more earlier and act as resolution applicants. Uh, so the another point that I was going for is their role in interim finance. Interim finance is where basically then IP is allowed to take over interim finance to run the CD as a going concern and to conduct the CRP. Now, right now, interim finance market, when you look at it, the rate for interim finance is very high. It's about 15 to 16% interest rate that is going on. Currently, RBI does not permit ARCs to give interim finance where they do not have exposure in that particular loan in the corporate debtor. I think this can be changed because there are sufficiently large ARCs, and in turn, what will happen is the ARCs will make money, and there will be more players in the interim finance market. This is something that RBI can look into. Um, the COVID pandemic affected a lot of businesses, so in a post-pandemic world, ARCs know which are the businesses which are affected by the COVID pandemic and which can be turned around in a couple of years, and they can generate more value, and the value may be less in a recent post-COVID situation, but it will unlock more value in the coming years. Apart from that, technological integration cannot be downplayed. There are it will enhance the accuracy in asset valuation and due diligence. Also, record trackings and everything. You can use blockchain for record trackings and the other dealings. They can use machine learning and adopt AI to see the distressed asset market as to which are so how an ARC normally operates is they take over the distressed assets. They can use these computation machine learning techniques to see which assets so they can pick on the asset very early in the market to take over the asset. Right now, ARCs, as we have seen traditionally, different ARCs are not diversified. So even the large ARCs, they invest in particular sectors only. We need to have more diversification so that the risk pool is staggered across different sectors, and the health of the ARCs is also maintained. So they can reduce this risk through portfolio diversification. Another thing is that India has become we're trying to portray ourselves as an investment place and investment behemoth. So these ARCs can forge partnership with global entities, private equity firms for resolution of large assets, pension funds. They can bring in the other high net worth individuals from outside, and they can leverage their international expertise and capital, convince players from outside India, and then forge partnership with them, and then try to act as resolution applicant. This is
So
for the
they can
large.
always, so what I understand from my experience is that there is no bar on any of these asset reconstruction companies to set up what is called the AIF.
Yeah.
And I don't think when they act as a resolution applicant through the AIF route, they will encounter any of these, entry barriers, which they do as a licensed ARC entity. So that arbitrage is already available to them, is what my point is.
Oh, but when you look at the AIF route also, even currently when you look at it at the NPS level, only 5% is on AIF, and AIF is not all this. There are other REITs and everything obviously there. Apart from that, with the FDI policies in place, and it attracts to AIF. So we are not looking at that. So to counter that and make sure that it's complementary, we can bring in foreign investment. I think there's much more that needs to be done here. ARCs are very vocal on this, but I think on a policy level, I think there's much more that can be done here on an AIF level. Then you can have an enhanced regulatory overviews. You should anticipate stricter regulatory measures for greater transparency. There have been issues with how ARCs take over the capital and become resolution applicants in the past also. So there's no malfeasance or malified actions by ART, and ensure stakeholder protection and accountability while they act as RAs. Apart from this, there's nothing to prevent the ARCs from taking standard assets also, and assets that have very recently gone bad. So they should incorporate more technology in how they operate, so that they can detect early and intervene in potential insolvency cases. And they should offer preemptive restructuring solutions, which they are an expert at anyways. ESG considerations are something to be looked at from future perspective. The World Bank is also trying to bring in a new policy. So the World Bank business rankings report, the ease of doing business is now being replaced, and now the new scoring factor that is coming in place has ESG factors also there. So that will also be a consideration. Apart from this, the ARC should invest in training programs to enhance their professional capabilities. Another one point, this is a mixed thing, but NARCL could have a central role in consolidating and resolving large stressed assets. We don't know how, we don't have sufficient experience right now. Players like NARCL, as we have seen in China, there have been about 4 state NARCL-like entities, and what they've done is it might help to get better price discovery, but we need to see more experience in this regard, and be continuously vigilant so that we help entities like NARCL to perform well. Any questions?
Thank you, Mr. Asit, for such a vibrant presentation and highlighting the key challenges. Yes, questions, please.
Yeah, it can happen. It can happen, but that will not be a CRP situation, obviously. But these ARCs, they can lend their expertise role, and the board of management will be separated, and the VC funds would, what they'll do is they'll bring these ARCs in, and they'll run the company for some time, restructure it, and then pass it over to some. This can very possibly happen. Yeah.
I haven't seen ARCs coming at a very early stage.
Yeah, so far they have not.
I haven't seen that. So I don't know how many of you track Sanya, the advisor to the minister.
Sanjeev Sanya.
Sanjeev Sanya. You should. It's easy to sit here and give a policy prescription, but what works on the ground is something that we have to appreciate. He's very recently written an article on mediation. As opposed to the conventional wisdom here or anywhere, most of you will say that mediation should be made compulsory. Are you with me? Most of you will say that, isn't that? Sanjeev Sanya, advisor to the Prime Minister, has said the other way. He said it should be voluntary. Because he's the guy who works on the ground and looks at data, looks at what works in the real life. We can sit here, think of anything. Yes, there can be many prescriptions, but we have to see what works on the ground. In my personal experience of insolvency resolutions in 7 years, I don't see mediation working at all. The creditors, oh my God, they treat debtors with such disregard, you cannot imagine. They won't sit across the table with themselves. And it's not a dispute, it's recovery. Mediation is where there is a dispute. Here, the creditor has a recovery against the debtor. Where is the dispute? What are we trying to fit here? It is being very often taught that we should have mediation in insolvency proceedings. I'm sure there is a role of mediation in certain settings of the insolvency processes. Yes, even NCLT has appointed court commissioners to allow mediation between parties where they don't want to consume the time of the court. And NCLT, as such, being a summary proceedings court, doesn't have the luxury of spending too much time. So very rightly, it is a prescription available on the table for you. But I don't think it is something that you can impose. It is something which can work on a selective basis. And still, mediation is something I haven't seen working on the ground anywhere. Arbitration maybe has taken off better than mediation. I think people are still averse to mediation. We'll have to really wait for it to work.
So, in US regulations and taxation insolvency to resolve the bankruptcy.
There are much more evolved bankruptcy regime. You please look at when was the US bankruptcy law enacted. We are just 7 years old, and we have to understand our own culture, society, the construct of our society, our people, our attitude, our way of looking at things, which is very different from US. In US, I think all of us know that Donald Trump went through many bankruptcies. He was also the president of US. It's a very defining thing in US. I don't think as a society, we have still come to the terms that, a bankrupt person is just a normal person. Is that, I don't think that is the case today. We are looking at fresh start, we are looking at bankruptcy, we are looking at bankruptcy registers. But I think the stigma with bankruptcy in India is not going to go away, like possibly in a developed country like US. Yeah.
I'm sorry to interrupt at this juncture. I will not take any more questions. Next session was supposed to start at 2. It's already 2:10. So we'll be starting next session at 3. That means sessions will end at 6:30. So we can't detain the participants even of online presentations till that time. So if there is any more discussion, we are proceeding to lunch in the guest house. We can discuss over there. I'm so sorry to cut short this session. I'm thankful to Ms. Namisha Singh and Ms. Archana Sharma, Mr. Asit Behera, and especially to Mr. Anil Katia for giving insightful thoughts on the working of the Insolvency and Bankruptcy Court. On behalf of Rajiv Gandhi, National University of Law, I'm grateful to the officers of IBBI and Mr. Anil Katia ji. I'm also thankful to all the participants. Now we need to proceed to lunch. I'm so sorry to have cut short. Thank you so much.
हेलो हेलो चेक देखो जी हेलो हेलो चेक वन चेक हेलो वन चेक हेलो चेक ठीक है सर ओके जी हाँ जी ठीक है It's okay. I बस ठीक है कोई नहीं शी इज राइटिंग Dr. K.D. Singh, sir, Director CCI. Mr. Anil Katia, Insolvency Professional. Mr. Abhinav Gaur, Practicing Advocate, Allahabad High Court. Dr. Manoj Kumar Sharma, Convener of this conference and Coordinator CBLT. Dr. Brinpreet Kaur, Co-Convener of this conference. Senior professors, faculty colleagues, participants, paper presenters, my dear students, ladies and gentlemen. A very warm good morning to one and all present here and to everyone who is watching us live on YouTube. I, Dr. Ankit Shrivastava, co-convener, welcome you to the second day of the National Conference on Insolvency and Bankruptcy Code, Implementation, Efficacy and Impact, organized by Center for Business Law and Taxation, RGNUL, in collaboration with Insolvency and Bankruptcy Board of India. This session is quite a special one, as we have amongst us most distinguished speakers having expertise in the fields of IBC and the related areas. We have organized this panel discussion to focus on the interplay of IBC with other related laws, such as competition law, RERA, Taxation and Limitation Act, etc. And we are proud and honored to have the best of the people with us to discuss on the same. We are sure that the attendees and the participants shall have various key takeaways from the panel discussion. At this juncture, I request the convener and the co-convener of the conference to extend a green welcome with planters to our esteemed guests. Dr. K.D. Singh, sir. Mr. Anil Katia, sir. Mr. Abhinav Gaur. Now I take this opportunity to introduce to you the panel of experts and the moderator of the panel as well. So we have with us Dr. K.D. Singh, sir, Director Law in the Antitrust Division of the Competition Commission of India. During his stint in the CCI, he has worked on conduct cases of cartels and market abuse. On the enforcement side, besides engaging in sustained advocacy initiatives with different stakeholders such as industry associations, trade associations, consumer associations, academia, etc., as also the various government departments, both at central as well as state level. Dr. Singh joined CCI in the year 2010 and one of the pioneers of the experts with the Competition Commission of India immediately after the competition law was made operational. Before joining CCI, sir has served as a professor at Campus Law Center of University of Delhi for over 5 years, where he has taught various disciplines such as competition law, corporate law, labor law, and international trade law. He has also practiced law before various courts, tribunals, and regulatory bodies. Dr. Singh has vast global exposures as well. He has presented various papers in the various conferences and seminars organized by various renowned international bodies such as UNCTAD, OECD, etc. He has also been on deputation in the Competition Commission Bureau of Canada, as well as the International Visitor Leadership Program hosted by the US Department of State at Washington, D.C., California, and other locations in the United States. We thank you, sir, for taking out time from your busy schedule and joining us for this conference here at RGNUL. Thank you, sir. Next we have is Mr. Anil Katia. Sir is currently the whole-time director in an IPE, Ductrus Resolution Professionals Private Limited, and also director in Ductrus Advisory Services Private Limited. He has since worked on numerous transactions in insolvency resolution and has over time gained expertise to handle some of the most complex issues involving resolutions. Further, he is the on behalf of IBBI as a trainer on insolvency and bankruptcy code and has undertaken many programs for Income Tax Department, DRT, and MCA. He is also guest faculty at IICA, active contributor on the amendments in the code and regulations for better outcomes. Earlier to becoming insolvency resolution professional, he has also worked in wholesale banking in the HDFC Bank and IDFC Bank for nearly 18 years. Developed deep understanding of interlinkage between finance, legal, and commercial aspects besides technical, and a problem solver and IQ for business models in a fast-changing world. His areas of interest include public policy, e-governance, structured finance, M&A of both stressed and healthy firms, debt resolutions, etc. Thank you so much, sir, for accepting our invitation and being here with us today and gracing this event with your presence. Thank you. We also have with us Mr. Abhinav Gaur. He is an advocate practicing banking, finance, insolvency, and bankruptcy constitutional matters before the Allahabad High Court. He is also regularly appearing before the National Company Law Tribunal, where he represents various banks, financial institutions, and companies. He was also appointed as an alternative chairman by NCLT Allahabad in a matter under Section 230-232 of the Companies Act 2013. He recently was also invited as a speaker to present his views and suggestions on the Forest Conservation Amendment Bill before the Parliamentary Committee of the Lok Sabha. He is a member of the Allahabad High Court Legal Service Authority and provides free legal aid to those in need. Thank you so much, Mr. Gaur, for sparing your valuable time and being here with us today. Now, we also have the panel being moderated by our very own Dr. Manoj Kumar Sharma, sir. He's the convener of the conference and the coordinator of CBLT. Sir, as most of you know, is one of the dynamic personalities of RGNUL and all-rounder, be it academics, administration, and research. He is serving as an associate professor of law and in charge of the IQAC at RGNUL. He has drafted new innovative course curriculums at RGNUL and displayed new teaching techniques in teaching procedural laws as well. He has successfully guided PhD candidates and more than 20 LLM dissertations. He has been appointed at various Institute of Eminence like the IIM Management, Indian Institute of Management, Ranchi, and various NLUs as a visiting and guest faculty. Keeping in view his expertise in procedural laws, he has been invited to deliver lectures to aspirants of judicial services by IAS Training Centers of Punjab University, Chandigarh, and IAS Training Center of Punjabi University, Patiala. He has written multiple books and has various paper publications on varied fields of law. He has been an integral part of RGNUL for almost a decade now, and we couldn't have asked for a better moderator for this session. So I welcome you, sir, as a moderator of this session, and I hand over the podium to you to continue this discussion. Thank you so much.
Thank you, Dr. Ankit, for such a generous introduction. Now, coming to the panel discussion. As we understand, we have been discussing since yesterday that IBC, the Insolvency and Bankruptcy Code, enacted by the Parliament in 2016, is a path-breaking legislation which has made a new market of insolvency resolution professionals, particularly with the view to solve the problem of NPAs and to maximize asset value, as we say, and for resolution of distressed entities. But any law, for that matter, cannot operate in a vacuum. So this panel discussion is being organized to understand the interface of Insolvency and Bankruptcy Code with other laws, since the panel discussion is only for 1.5 hours, at the max 1 hour. So we cannot touch upon all the laws with which IBC has an interface with. So we'll be confining ourselves to a few legislations, particularly the competition law, for which we have with us Dr. K.D. Singh, the Director, Competition Commission of India. Some aspects of the challenges being faced by the resolution professionals, for which we have an eminent insolvency resolution professional, and of course the interface with PMLA and RARA Act, we have Mr. Abhinav Gaur. To set the panel discussion rolling, I would like to know from Mr. Anil Katia that what are the key economic laws with which IBC has a regular interface in a routine manner?
So very interesting. I've been practicing IBC now for nearly 7 years. When I actually started looking at the interface, to my surprise, every other law, economic law, IBC has an interface. And the list goes on and on. I looked at the various economic laws that are there in our country, you name it, contract law, income tax, GST, PMLA, SEBI, the list goes on. So the ambit, the interface of IBC with other economic laws is very, very wide. You have to be really learning on the job to actually acquire the skills to interpret what you are confronting. Nobody, I think, nobody can claim to be an expert in so many economic laws. But what is that I can recommend to all of you is that if you build a conceptual understanding of the business environment and the laws that are required or enacted, I think that itself sets the foundation for you to work in insolvency resolution processes. That's why I look at it. From a very specific standpoint, IBC is a special legislation. IBC also has non-obstante clause like other special legislations. But what we have to understand is that any such legislation will always have some conflicts, and some of the things you have to interpret harmoniously with other legislation. You can't have everything being overridden by IBC. That can't be the case. You have to go to the objects of IBC. What is the objects? What I can simply tell you is that IBC does essentially two things. It actually defines the liabilities and the waterfall. How do you distribute? How do you distribute what you collect under the insolvency estate or a liquidation estate, as the case may be? That is on the one side. And on the other side, you have the assets. You prevent individual creditor actions, which will actually depreciate the value of the insolvency estate. You don't allow that to happen. But at the same time, you have exceptions. The government very recently notified that the lessors in the airline business can still repossess. The moratorium will not be applicable. There are reasons to these exceptions. So one has to really understand what is before you. So it's a very dynamic law. It's a very open law. You have to apply this law to facts and circumstances day in, day out. And the interpretation and the outcome varies. And I've seen this happening every day. There are a variety of complexities that we come across. And the only way, I think, over time this law will evolve is when you apply to so many facts and circumstances, like any other law for that matter.
Thank you so much, sir, for setting the tone of this panel discussion. So as an insolvency professional, we believe that one of the issues which the resolution applicants have been facing is regarding the notice and approval of the Competition Commission of India with regard to the combinations arising out of corporate insolvency resolution process, if it forms part of the resolution plan. Before 2018, there was an ambiguity regarding the stage at which the notice has to be given to the Competition Commission of India. Though the 2018 amendment has amended Section 31, subsection 4, and inserted a proviso, yet due to the judicial decisions, there is still some sort of ambiguity at what stage the notice is to be sent to the Competition Commission and approval is to be taken. So I would request Dr. K.D. Singh to enlighten us on that issue.
Thank you very much. Now, as was pointed out by my co-panelist, IBC has interfaced with many economic legislations. Now, in this framework, and particularly, you will find two sections in every statute. One is the provisions of this act are in addition to any other act for the time being in force, and second is the non-obstante clause, that is notwithstanding anything contained to the contrary in any other law for the time being in force. This is a typical judicial conundrum. Now, at CCI also we are in a very unique situation because unlike a sectoral regulator, for example, SEBI, it looks into the capital markets. IRDI, it looks into the insurance. RBI, banking. So, unlike a sectoral regulator which has its very laid out mandate for the specified sector, CCI as a market regulator has an overarching presence across sectors of the economy. So we look into aviation, we look into business, insurance, entertainment, commodities, digital, everything. And wherever these sectors are regulated sectors and there are sectoral regulators, CCI does have an interface. Now, this is a larger issue which he has flagged, and I also want to address it. What you have asked is a very technical question, and of course I will answer to that. But this is the larger picture. Now, CCI in this overarching is at the hub, and then there are sector regulators. Now, the moment if you take up a case, let's say from real estate, there is a RERA. If you take the case from capital markets, bulls cartel, bear cartel, then there is a SEBI. And then there are two provisions I have said, and there is nothing specific or special about these provisions. You will find these two provisions in the Competition Act, in the IBC, and in the respective legislation governing the sectoral regulator. So how do we interpret it? So as was said, we have to see the context. So the text is as far as it goes, but beyond that we have to see the underlying legislative scheme. CCI is this inter-sectoral regulatory mechanism. This is a very important issue. And I would call it a committee of regulators, that we all must act harmoniously. And we should not provide any regulatory arbitrage. If we allow these gaps and overlaps to flourish, then it will derail the entire process. So therefore, it is of paramount importance that there must be a committee amongst all the regulators. There should be a regulatory harmony. And in CCI there are provisions, section 21 and 21A, these are mirror age provisions. CCI can consult sectoral regulators can consult CCI. And in the recent amendments to the Competition Act, this mechanism has been further broadened. Earlier, the consultation was only when there was a conflict. Now, so that conflict is required. So if we receive a matter from banking sector, irrespective of conflict or no conflict, we can speak to RBI and RBI can speak to us. So that threshold has been lowered. So now we can speak more and more. So more engagement means more informed decision of the regulator. So this is the larger issue flowing from what Mr. Katia said very correctly, that IBC has interface with so many legislations. And if you have more interface, there can be more chances of frictions, and how to minimize them. So my way forward is, let's go for committee of regulators. And CCI does have these provisions, and Supreme Court has interpreted in Bharti Airtel case also how this inter-sectoral consultative mechanism will work. Now, coming to this specific question, this very pertinent question which has been posed, that CCI has one mandate, that if you enter into M&As, mergers and acquisitions, beyond specified thresholds, which are in terms of assets and turnover, and which are fairly high, if that is triggered, then you have to obtain approval of the CCI. Without CCI approval, that merger cannot be consummated. Now, the question was that in IBC, in the resolution process, if there are 3-4 applicants and they have to go to the committee of creditors with all the regulatory approvals, now what is the stage when they are submitting their bids to the committee of creditors? At that stage, should they have the CCI approval, or it can come later at the stage of adjudication before the NCLT? Now, already I think the question was fairly answered, that earlier the law was in a situation of flux and there were contrary rulings, but as I understand now, the law has settled, and now these bidders in the insolvency process, they can go to the committee of creditors even if there is no approval at that stage, but this approval must come before the adjudicating authority. So before the NCLT adjudicates finally, even by the time if they bring, that will not trigger gun jumping. So gun jumping is if you are entering into M&A without CCI approval, that is gun jumping, and that's very severely punishable under the competition law, because you cannot consummate a M&A or any transaction without CCI approval if the notification threshold has already been triggered. So the gun jumping will not happen even if you obtain now this approval after COC, but you have to do it before NCLT decides.
Thank you so much, sir. We were going through some of the judgments once the amendment was triggered. the proviso to 31(4), which clearly states that the resolution applicant shall obtain the approval of Competition Commission of India under that Act, Competition Act, prior to the approval of such a resolution planned by Committee of Creditors. That remains the letter of the law. But then when we went through the decisions, for example, NCLAT decision in Arcelor Mittal versus Abhijit, NCLAT decision in Vishal Vijay Kalantari versus Shalin Shah, NCLAT decision in Makaru Trading Limited. And all these decisions, the rationale has been that probably even if the CCI approval has not been obtained before submission of the plan to the Committee of Creditors, that can be obtained later, as you have pointed out. So if that would have been the situation, why the legislature specifically provided this proviso for 31(4) in relation to the CCI? And if the proviso is saying that because the language of the proviso is the resolution applicant shall obtain.
Well, I can only say that irrespective of the phraseology used in the legislation, irrespective of that, ultimately it falls upon the courts to interpret the law. So there are settled canons of interpretation of statutes, and notwithstanding the usage of word shall or may, the courts, it is their onerous duty to interpret the law in the underlying spirit. Now, they have said that it is directory and not mandatory. This is what they have interpreted. So, there are various statutes which use the word shall, and the courts have interpreted shall as may. So, this is not something very unusual, I would say, the courts. But you are right, when the legislation comes with a proviso and if they use the word shall, then, well, all I can say, the judges, when they interpret the law, they inject flesh and blood into the legislation by experience. So long as the process is on and if the approvals can come, why should we, close the door? Our role should be to maximize the value. That is the whole idea of resolution process. Then why we at an anterior stage when the process is still ongoing and we say, so I personally tend to agree with the judgment which says that it is directory and not mandatory, and that is of course now the law of the land which we all are bound to follow. It makes more logical sense. But of course legislature wanted a discipline, didn't want to keep it open-ended, but it is not open-ended in that sense. Before NCLT approval, if you can bring, that's fine.
I just want to supplement to what sir is saying. So every time when we face such conundrum or the interpretation of the statute, I think let's go back and try and understand what would be the thinking of the legislature. I think they imagined or they presumed that there will be only one resolution applicant, which is not the case. Because if there was only one resolution applicant, that possibly could have led to an approval prior to Committee of Creditors. But in reality, there are multiple resolution applicants. It doesn't make sense that all of them file an application before the Competition Commission and unnecessarily burden them with the work because only one will succeed. So I think what has come out, like sir has said, is the way to do it, and I think it is very rightly implemented by the courts.
Sir, actually, I think that the logic behind introducing this amendment was that if you are filing at a later stage, CCI also has 210 days to approve a particular combination. And if IBC is moving on a time-bound manner, then I think it has 270 days to finish off the whole process, CIRP process. So if the approval is given at a later stage, then it becomes a problem, because if it has gone to a later stage and then CCI says that no, this combination cannot happen, then it becomes a problem for that particular resolution plan that has been submitted. And that is why I think, sir, the amendment was brought into such a place that before you are submitting it to the COCs, you should have the approval, or you should at least file it with the CCI so that you can have a timely approval from the CCI. Having said that, till today, sir, CCI has not taken more than 40 days in approving the combinations in any of the cases submitted to the commission.
if I'm not wrong.
Yeah, and particularly in the case of insolvency, the approach is more nimbler, as I can see. So effectively 17 or 20 working days time is taken. But yes, hypothetically you are right. A scenario may arise where these timelines may conflict and parties may face potentially gun-jumping provision. Because CCI after all had 210 days, and now with the latest amendments, 150 days. So I think this is going to be closer if there is really some serious combination is presented before the commission for approval.
Thank you, sir. Just to
The
add,
law provides, the law provides for 1 year of approval, and also this period is not to be counted for resolution timelines. This is a period which you have to exclude. So you can't really burden the resolution process, so to say, with what is required. So competition law is one, but the lawmakers have not only envisaged competition law as one approval, there could be variety of approvals needed. And in real estate, you have plethora of approvals. So the law provides for 1 year as a whole for all kind of approvals. So the same proviso which he's referring to has that you have 1 year available to comply with this.
thank you so much, sir, for the response. I would like to add a few more things to that. When we have a specific proviso for the competition, I mean, it's a special law. Fine. One is general proviso for all other enactments, and one is a specific proviso only with respect to competition. Probably the legislature had in mind that even COC would have the benefit of the opinion of the Competition Commission. If there are, as you said, 2, 3, 4 resolution applicants who involve combinations, and later on at the later stage they have to be ruled out, so the entire process would be set to jeopardy, as what Dr. Ankit has stated. Probably that might have been in the mind of the legislature. Just to add to this, one more point which we can take out, the conundrum of binding document for the competition, because as we understand, the 2023 amendments, which have added this explanation to Section 6 regarding other documents. So for the purposes of competition, when you have to take cognizance of a combination, other documents, including this resolution plan presented, that may be a binding document. But when we talk about the IBC, Section 31 is very clear. It becomes binding only when the resolution plan is admitted by the adjudicating authority. So probably that conundrum of binding documents for the threshold for CCI and for the IBC, that is different. And that is where that interface becomes rather more interesting. And that's where perhaps Dr. K.D. Singh is talking about, that conflicts might arise in future, and that is for the probably judiciary to resolve that conflict in future. That's how it stands. Further, moving ahead, as you have already pointed out, that the Competition Commission has resorted to fast track procedure for CIRP, and I was going through the data today morning, and we found that around 20 days is the time which you have taken for the resolution applications being undertaken by you. So, of course, that is the excluded time. But then in future, we expect that there may be flood of applications before you if the letter of law is interpreted literally. And then how do you propose to deal with that flood of applications, examining all those combinations from the competition standpoint? So.
Now the timelines are indeed very tight. Not only the outer limit is now 150, but even the prima facie opinion has to be found within 30 days. Otherwise, there is a deemed approval. Now there is a deemed approval at twin stages. One at the prima facie stage itself, that if 30 days you don't form a prima facie opinion, then the combination is deemed to be approved, and otherwise 150 days overall, then again it is deemed to be approved. So now there is a greater discipline and rigor in terms of timelines. Now, as regards CCI's approach, as you can highlight it from the data, the CCI has been fairly very fast in facilitating these transactions which are not problematic. And so I believe that this situation, of course, flooding, and now already it happens in the sense now 2, 3 applicants come to CCI, and CCI examines each proposal on its own merit. And green channel I will come to later, but even if it is not a green channel route, the approach is, as I mentioned, is fairly fast. So I presently see not much difficulty and not such flooding happening, because I don't think economy is in such a dire strait that farms are falling every day.
Thank you, sir.
I think, I just want to make a comment here. I think for CCI to decide a combination for an ailing company would not be that much of a challenge. You have to look at what is before you. You are trying to rescue an ailing company, a dying company. So I think they'll be liberal, like he said.
And yeah, actually,
They would be liberal.
we must be rather. The only point is that if a company is falling and there are 2, 3 claimants, and one company which is filing, let's say it is number 1 or number 2, the company which is acquiring is also number 2, and it is acquiring number 1 or vice versa, then that's a concern, a serious concern. Then CCI has to see whether this combination vis-a-vis the other, which is less problematic. So that is the only challenge before CCI. Otherwise, you are right. Failing farm is one of the factors in the competition assessment of combinations, and that is duly accounted for. Because ultimately, if it falls flat, then nobody gets benefited. So it is in the interest of everyone that farm should get going. And that should be our effort. That is the purpose of the IBC, and is the whole of the government approach. That is what we are also part of it, and we also look at it. But the only issue is when there are these big players, one big player is falling, another big player is, acquiring, and then there is some other option available. So vis-a-vis in that scenario, if some remedies, some divestitures, some, selling of assets, or if we can look at some remedies, so that there are no potential concerns of appreciable adverse effect on competition. But in principle, yes, in failing firms, approach should be more accommodating.
So you have the case of Goer going on. Should we pose a hypothetical question? So if Indigo was to bid, would you approve it? So please.
So we would not like him to answer that on this platform. Just to go ahead with what Professor Dr. K.D. Singh has said. So when we see the report of the Competition Law Committee 2019 report, which recommended this green channel route for combinations, especially under the IBC. And we were, scrolling through merger enforcement guidelines of the Competition Bureau of Canada also. So they have also talked about the green channel route or the falling from defense, which you are referring to. So please elucidate on this for the benefit of all the.
So green channel, those who are not much familiar with competition law, I must say, is a category of combination, that is merger or acquisition. Commonly is merger and acquisition M&As, but competition law uses the word combination, which may not give that much clarity. So green channel is a route where a combination, where A and B company, there is neither any horizontal overlap, nor any vertical overlap, nor any complementary overlap. So then it is the least problematic transaction, and it qualifies to pass through a green channel. So all that they have to do, they have to file a notice before the commission, and on the date of filing it is deemed approved. It's a green channel, like in airport when you come from abroad and you straight away you go, self-declaration. It is based on trust, ease of doing business. So if two companies, like two competitors, if they are merging, there is a horizontal overlap. If there is a vertical integration it is creating, then there is a vertical overlap, or there can be a complementary overlap. So in green channel, there is none of these types of overlap is there. So if that is the scenario, then we came out with the green channel. In fact, I must say, even prior to the CLRC recommendation, and we notified. Then CLRC made this recommendation, and finally now the Competition Amendment Act 2023 also has provided for green channel. The only distinction I would say, now you may be wondering, if it was already there, then what is that has been provided? Earlier we were doing it through our regulations, a subordinate legislation, but now that green channel dispensation has been elevated to the statute level. So now there is a greater certainty and predictability, because regulations are can be tweaked by the regulator, but the statute is parliamentary instrument. So if something is provided in the statute vis-a-vis something which is provided in the regulation, that will always inspire more confidence to the stakeholders that this is a mechanism which is available and it cannot be lightly interfered with or tinkered with or otherwise tweaked. So that is what has been provided in the 2023. But we have very presciently and perspicaciously had provided for green channel dispensation much before this act, much before the CLRC recommendation. Through our general regulations we had provided. So that route is, I must say this route is not particularly available for only these IBC cases. It can happen in any case. The only requirement is that there should be no overlap of any nature. So even if it is an IBC case, but if in IBC case, if there is a overlap, then certainly you have to pass through the rigor of the competition assessment. Of course, we may not take time unless it goes in phase 2. If it goes in phase 2, then it may take more time. But in phase 1, 20 working days. That is what the time we are taking. So that is the point I want to highlight. Green channel, of course, is available like any other branch for the IBC cases as well, but then there should be no overlap. If there is overlap, then you have to pass through.
Thank you, sir. So that takes me to the next point which Dr. K.D. Singh has raised regarding the real estate sector, and I would like Mr. Abhinav to answer this. When we see in the realty sector, we find that there has been significant policy confusion, if I can say that. Despite various amendments even to IBC and the policy flip-flops, maybe the home buyers have largely been on the fringes of the IBC, so to say. So though we today, the home buyers, they can, they are financial creditors, but then there is a difficulty in reaching the threshold of 10% or 100 home buyers as the case may be. And, but then that threshold is necessary to be the part of this. So how do you perceive the real estate sector, its interface with the IBC?
Thank you for your question, sir. I would say that Insolvency and Bankruptcy Code is perceived to be a complete code, and like my co-panelist also said, that it is a whole code in itself. However, in terms of real estate allottees or the home buyers, this code as it was enacted did not perceive or did not have the home buyers into consideration when this was enacted. And that is how the jurisprudence surrounding the home buyers evolved eventually. And I might not say that it has evolved completely, but it has brought dust to the ground to a certain extent that now the home buyers are guided, legally advised to show where they stand in terms of insolvency proceedings are concerned. Where we say that, for this matter, in fact, this judgment of Pioneer 2, as we say, has also clarified this position, saying that whenever there's a home buyer who comes to any lawyer for advice saying that I want, my unit is stuck, I do not meet the threshold under the IBC, which has now been risen to 1 crores. Do I go under the Consumer Protection Act? Do I go before the Real Estate Regulatory Authority? Do I file a civil suit? Or do I straight away come to Insolvency and Bankruptcy Code and NCLT as well? As a lawyer, we advise them to understand what is their perspective, what are they looking at in the end of it. If they're talking about a real estate company which is filled with creditors, and home buyers being just a peculiar class of it, then to advise them to say that you come and take a recourse under Insolvency and Bankruptcy Code might be good at the very instance of it, but when we talk about in the end, when the resolution plan is enacted, it has been all in jeopardy. The classic example is the Jayaprakash Associates matter. I am having the chance of representing about 300 and odd home buyers before the Allahabad High Court. And this litigation is pending since 5 years now. Till now, no end to it. And in the meantime, much water has flown. What is it? Some of those home buyers who have already availed a remedy before the Allahabad High Court have simultaneously availed a remedy before the real estate regulatory. And they have also got the decree. Now the only proceedings pending is the execution. Now there are 3 proceedings before this on the same project. First is the Allahabad High Court, where the development authority has cancelled the lease of the land over the project, over which the project was to be constructed. On that particular piece of land, about 20,000 crores have already been taken from the allottees, which we are saying is around 80%. So 80% money given, no constructions. Number 2, home buyers are already before RERA, before execution proceedings. So everything is done, decree, they already have in their favor. They're just asking for the money back. Third is now this proceeding, which was also initiated forums, and now 2 forums, RERA or Allahabad High Court. And although the judgment of Supreme Court is very clear, even Pioneer is there that IBC, RERA can coexist, different remedies, of course they are different. RERA is recovery, IBC is not recovery. The intention at least is not recovery. But where do the home buyers go? So home buyers are, as we speak today, in terms of the books or the statute as we say, they are clear where they stand. But in practical sense, if we really listen to one of the home buyers amongst the thousands of home buyers, we'll be stuck. Where do we advise them to go? I literally had, against my advice, my client asked, the home buyer asked me that you file a withdrawal application before the Allahabad High Court and we are about to get a relief before. It is a so home buyers are stuck. In respect to the second question that you posed, the former part, the second part was the possibility of meeting the threshold of 10% or 100. Again, the law is settled, but for the sake of discussion, the law as it stands under the statute and as it has been upheld by Supreme Court very recently also, we understand that the only purpose is that we are talking about not creditors, individual like sir said. We're talking about different classes of creditors. Home buyers are, and only in real estate projects, are forming a very voluminous, but only a particular single class. So to restrain a disgruntled single home buyer to approach NCLT saying that I want my money is fair embargo or threshold that has been put under the statute. This case also goes when we recently were talking about this when during the COVID the threshold was risen from lakhs to the 1 crore. It was the question that before the amendment, an employee whose salary dues were meeting the threshold would easily come before NCLT. But now, on one hand, when the Act is saying that, all right, to meet the threshold under Section 7, under Section 9, a joint creditors can come and approach. But so far as employees are concerned, in a company, how many employees will be there who will single-handedly have the capability of meeting the threshold? The same goes with the home buyers. That is why this class has been provided so that you can also meet the threshold and you can also come up in a form of a class which would justifiably stand before the court and say that I am not disgruntled, but I am being persecuted by the real estate company and hence hear me out.
Thank you so much. That takes me to another aspect which you referred to. When we talk about RERA, I came across one matter where some of the home buyers, they approached UP RERA and they obtained decree for refund of money along with interest. And in the meantime, the CIRP was initiated and the resolution professional, what he did, he said so far as these home buyers are concerned, who have obtained a decree from the UP RERA, now they form a class apart from the other home buyers. Fine, and therefore in the resolution plan which was presented therefore, the favorable terms were given to those who who have not approached the UP RERA, 50% better conditions, and others were given discriminatory condition because you have obtained a decree from RERA and therefore you stand as a secured creditor. probably the same position which in SR, the stand chart had. So now you stand as a secured creditor, so if you dissent, you can have your liquidation value. And otherwise, so now they created a class among class. So, I mean, how do we deal with it?
I think that will be in furtherance of the discussions that I was just having. Similar, this case is very recent, as you said, and the court has held that you cannot create a class amongst a class which has been formulated not by way of judicial precedent but as a statute as it exists. So you cannot sub legislate by way of the judgment, and this is what is happening in the Jayaprakash matters also, and this matter also. It has been done, in fact, has been ruled that there is only one class that exists. That is the allottees. Similar to this reasoning was the case of Purvanchal Vidyut Nigam, which was before the Supreme Court. There, the electricity dues, the Insolvency and Bankruptcy Code will not have a superseding effect over the provisions of the IBC. And similar to that extent, in this judgment also, it has been said that security interest, when we are talking about, that is one factor which will facilitate the differentiation between the creditors. You cannot say that I have a security interest in some other law, which otherwise under the Companies Act is not even registered under Section 77. So if it is not there, and if IBC does not recognize it, you do not fall within the ambit of security interest under the IBC, you will not be able to claim a higher preference under the waterfall mechanism. And this has been upheld till the Honorable Supreme Court.
Just to add to it, when we see the Transfer of Property Act 1882, so there also we find that the buyers will have a charge on the property if they have paid to the extent of the consideration paid by them. So now there's another law, not only the RERA, but then the TPA, then IBC. So there are multiple enactments, and as you suggested that, of course, the high courts, the people are approaching, they are approaching civil courts also. So even TPA is giving the same kind of charge. So how do you write it down, probably using 238 or what?
In practical sense, I am currently contesting a matter before Allahabad High Court, which is the fourth writ petition on behalf of the same petitioner, which is a successful resolution applicant. What is happening is that either the government authorities, the government officials, if you can say, are not being educated about what to be done after the resolution plan has been approved, or they are playing around at the cost of the resolution applicants or say the stakeholders of the Insolvency and Bankruptcy Code. Why this fourth petition? The first petition was under the water tax. They said that we had raised the demand, you had not honored, so now recovery certificate has been issued, and water tax assessment has been done by the municipal authorities, and the execution is being done by the Tehsildar and the district magistrate. So that's one. Number two was electricity. There also we have Purvanchal. Yes. So Purvanchal is also doing this. They have done this. Allahabad High Court has set aside the first demand, set aside the second demand. Now on the fourth petition, when we are there, we are again against the same respondent who is merely acting at the behest of some other instrumentality of the state, municipality, electricity discoms, or property taxes, or bankers for that matter, who have not participated in the CIRP process. They are just issuing the instructions to the DM. DM, without application of any mind or seeking any principles of natural justice is being followed or not, although he is not required at the execution stage, is simply set up giving the recovery certificates. Now this question was involved is we had prayed for a writ of mandamus saying that you direct the district magistrate that at least before issuing any RC with respect to this particular petitioner, because this is the fourth that has fallen from him, at least ask him to verify that this RC is being issued against the erstwhile management or the person who has taken over the company now. And under the statute, he is not obliged to pay you even a single penny. But then he is being dragged into court. He is being pulled up in the court, filing petitions after petitions. He is succeeding. But then to drag a person to a court is also frustrating the process. And this has been quoted in the Ghanshyam Mishra case. The Honorable Finance Minister, when she was deliberating upon the amendment that was brought in 2019, she said, if I may quote, the government will not raise any further claim the government will not make any further claim after resolution plan is approved. This is the minister saying in the parliament. So that is going to be a major sense of assurance for people who are using resolution plan. Criminal matters alone would be proceeded against the individuals and not the companies. There will be no criminal proceeding against the successful resolution plan. Why I'm saying criminal is that if you do not honor the recovery certificate under the UP revenue code,
Yes, you can do.
everything will be sold out.
Arrest intention is one of the most.
So
yes.
that I think should answer it. Thank you.
I have a linked question actually. So this is something which is engaging my mind for quite some time. So what is IBC? IBC is a central piece of legislation. Okay. What you are doing through this, you are taking away the state's ability or state authorities' ability to raise revenue or collect their revenue. Can you do that?
In here, since the question raised is of constitutional importance, so therefore I can pitch in. There are two things which we need to keep in mind. In Indian legislative scheme, the general subjects of legislation and taxation subjects have been clearly demarcated. So if the general subject of legislation is embarking upon the taxation matters, of course taxation matters will have their say. Because taxation is the sovereign power of the state as well as of the union. And taxation powers are very clearly demarcated. If we see 7 Schedule List 1, entries 82 to 92, 92C rather, read with 96. They're all taxation subjects. And they have been clearly segregated from the general subjects of legislation. Same as the state list. If we see list 2 of the 7th schedule, entries 45 to 63, list 2, they are only dealing with the taxation matters. So general subjects of legislation and the taxation subjects, they have been very clearly demarcated. So the general subject of legislation will not be touching upon the taxation aspects. So taxation is the sovereign power of the legislature, state and center. So that is where if there is a conflict which is irreconcilable, then Karunanidhi, the Constitution bench, 1979 decision that prevails, whether that conflict is in respect of list 3 or list 1 and 2. So if it is in respect of list 3, then of course the parliamentary legislation can prevail, provided the conditions are satisfied. But if it is in respect of list 1 and 2, then we have 7-judge bench decision in Dhillon judgment, that is 1972 judgment. So that is where they will have to see where the pith and substance of the legislation is. So therefore, the legislature with whom the pith and substance is, they will also have the ancillary powers. So it is on case-to-case basis which we have to decide the legislative competence of the legislatures. Just to add to it, if I can go further, because I see the time is almost over. So just to wind up this matter, I was going through this, the CIRP of Supertech Limited, where the NCLAT took one stance, and then when we went through Umang Realtek's insolvency process, where the concept of reverse CIRP was pioneered, so to say, the NCLAT took other stand. So in the first case, they are saying, okay, fine, that if in case of home buyers or in case of real estate, if the corporate debtors, one project is not to be seen, it is the corporate debtor as a whole which is to be seen. But then other case we are saying, okay, fine, that the moratorium is applicable only to the specific project and not to the entire corporate debtor. So probably there appear to be some sort of conflict even in the decisions of different NCLATs. And now we are talking about reverse CIRP, and what we believe from the discussions yesterday, probably even the legislature is going to come up with some sort of amendments to that. Anything which you wish to say on that?
I think Mr. Katia will be able to elaborate that pretty much. But just to say that, I would say that, like I began, IBC, I'm a 2015 pass out. And this code came into being as I stepped into the profession. So I have evolved as a lawyer as much as this code has. And I can say we both are still evolving and learning from the process.
All of us are.
Insofar as pioneer case is concerned, that judgment is obviously I would not say it in conflict, but it is more of a clarification, or I say would give a reprieve to a real estate buyers, real estate allottees, because the intent of the legislature cannot be deciphered from the parliamentary debates in this matter. They have been done insofar as the home buyers are concerned. The Supreme Court said that, okay, you will be identified, and then the amendment was brought in and all. The intention of that in that judgment is to save 10 projects, if they can be saved, and only one can be put to test. Right now, as it was happening before, was, like I said, the 10% conundrum of the home buyers. The entire company was tossed off. And tossed off in the sense that for a normal businessman, I would say litigation, just mere commencement of litigation is a threat to the business insofar as insolvency proceedings are concerned. So this judgment would give a reprieve to a real estate company, saying that, okay, if there is one project that has been put to test before the court, so your other projects, if you are able to complete that, or if they have been completed or near closure, will be saved from the plethora of cases or the proceeding that may ensue. But then I would like Mr. Katia just to add on to my
To jump to him in a short while, let me first put the last question to you before I jump to him. I was creating the data from the Insolvency and Bankruptcy Board of India website, and it came out that only 8% of the insolvency cases in the real estate sector have resulted in approval of resolution plan. And approximately 25% have resulted in liquidation. So that being the scenario, I mean, what do you think? I mean, do you think this RERA is a better alternative for the persons, or probably IBC? I mean, how do you believe is the better?
To be very fair, and I give this advice, I give this paid advice to my client, who are the home buyers, but let us bring it out on the live channel also. Whenever a home buyer comes to me, I never suggest him insolvency. I never have, till now. Although I have represented the home buyers, I was a part of the JP matter when it was before NCLT Allahabad, then it later on got transferred to NCLT Delhi, and then I was off that matter. Because if I put myself into the shoes of the home buyer, I will never go before a tribunal to say that this management is not working fine, substitute. I just want my unit or my money with interest. None of that can be ensured. I'm not saying can be done, but ensured by NCLT. That can only be ensured by RERA. I think that I will rest it there.
Therefore, that takes me to Mr. Anil Katia. So because of this interface with so many laws, you being an insolvency professional, what are the challenges being faced by you because of this interface with so many laws?
I think the paucity of time is holding me to get into that. Let me first react to what he has raised, a very interesting point. And this point has been coming to me as an insolvency resolution professional since quite some time. And what is not appreciated across the board, I'm going to make that point here. RERA doesn't understand what is an insolvent company or a solvent company. Does RERA have that mechanism? So I think that answers everything to me, at least. When we are applying RERA or insolvency, we have to see the financial health of the company. You cannot find answers in RERA if the company is insolvent. RERA only has efficacious remedy when there is surplus, when there is net worth, still residual net worth available, and also the wherewithal of the allottees to come together and resolve the asset. In my experience of 7.5, 8 years, I have yet to come across a successful resolution which the RERA has ordered. There are few orders which have been issued by RERA, but they are still under implementation. I see a lot of gap. I see a lot of gap both at the level of management capability to really execute a complex real estate project. It's not as simple. It's not really, you just have to build a building. It's not as simple. Second is, there is no uniformity of approach across states. RERA is a state law. I think maybe UP RERA has done some orders. Haryana has done some orders. But I am privy to discussions where the government is holding itself deliberately to allow the takeover of projects because they don't have the confidence that this can actually bring out the results intended. Yes, I agree with you that IBC has not produced the real estate resolutions that we are all looking for. But I don't think there is anything lacking in IBC. At the same time, there is nothing which is lacking in IBC for the real estate resolutions to happen. The only issue is how do you apply the law, and that is where the gap is.
Just to
If
add,
you, yeah,
just to add
let
one
me
more
just
point.
complete. Yes, if you just have the right set of people put for the job, and you have a certain regulatory support, which of course the IBBI is trying its best to rewrite the regulations and come out with specific prescriptions for the real estate sector, I think we can achieve a lot. The only stumbling block, which I also hear from what you said, is the authorities. The Noida and the Greater Noida. They are so arrogant and so abusive of their power that I am at complete loss. They just don't want to listen to anybody. They don't even care about Supreme Court, sir. I'll say it on record. So the issue is that we need people like him. What a vision. I was tempted to ask him a question that possibly, after hearing him, the competition law regime in India is by far possibly ahead of the developed countries. Am I correct, sir? Whatever he's saying tells me that we are ahead of the developed countries like US, UK markets, It cannot be better designed than what he said. So why can't we import this understanding with the state authorities? And the resolutions will happen. So I think the issue is less with IBC. It's more with somewhere else. Yeah.
To add one point, what Dr. K.D. Singh said at the outset, that committee of regulators, that is very, very important point. Even in HERA, because it's believing that we are an island in itself, and for independent Ireland, we don't need to consult other regulators. That is one point. But the Act is fair enough. Let me put that on record. Act itself contains provisions for conciliations, then she might dwell on that later. So not many states have established conciliation forums for that purpose. So maybe the Act has provisions, but then we understand the implementation is an issue, not with all the laws, but some of the laws we have the issue with the implementation also. And then...
Surfacy, sorry to interrupt. Yes. Surfacy always had the provision to take over the company. You can have the provisions, but you have to have the mechanisms, the institutions. Please respect that. An insolvency professional is a live animal sent out in the market, not only to implement the law, but also to discipline the stakeholders. Do you have any parallel? Today, everybody is looking up as IBC as a benchmark legislation to resolve everything which is wrong in the legislature in any commercial law. Isn't that the case? That's why we are calling it a path-breaking legislation. It's become the, people are saying IBC should be the panacea for all ills now. They are looking for everything in IBC. For example, the issue of operational creditors, that they're not getting money, is actually not the issue of IBC. But everybody wants IBC to give an answer. So we have to really see this, that how will we resolve these things from a public policy perspective? What is that we want to achieve from which legislation?
Thank you so much, sir. Keeping in view the paucity of time, we have 2 technical sessions scheduled at 12. I'll have to wind up this discussion. I'm grateful to Dr. K.D. Singh for his remarks regarding competition law, and of course for enlightening us the way the Competition Commission is working ahead of time. Of course, I'm grateful to Mr. Anil Katiaji. He has been here since yesterday morning, and he has been engaged in enriching deliberations on various aspects of IBC. And of course, I cannot forget to thank Mr. Abhinav Gaur, because he has brought a new light into the RARA and other laws. Of course, we had many other questions to discuss the interplay with other laws, but unfortunately, we are running short of time. Thankful to you also. Over to Dr. Ankit now. Thank you.
Thank you, Dr. Manoj, sir, for this, I think brainstorming session that we had. And thank you to all the speakers also to, bring in light whatever is going on contemporary with respect to the law, with respect to the interplay with the other laws as well. So I think I had a very interesting session. I learned a lot today. Thank you so much to all the three speakers and the moderator as well. I would now request the convener and the co-convener to please felicitate the guests. Okay, sir. I will. Dr. K.D. Singh, sir, Mr. Anil Katia, sir, and Mr. Abhinav Kaur.
So we come to the close of this session. We thought yesterday, we discussed with Mr. Katiaji that we'll have some question answer session, but then IBBI people have also to leave. So we have to wind up this session right now. We are starting the next two technical sessions in around 20 minutes from now. Technical session 3 will take place in this conference hall, and technical session 4 will take place in conference hall 1, first floor. All of you are invited for having a cup of tea before the technical session starts. Yes.
Move towards the porch for the group photograph. Thank you.
At the National Company Law Tribunal at Ahmedabad as the joint registrar.